call the first case on this morning's docket, and then I'll have a little bit of introduction to do before oral arguments proceed. That is case number 110054, State of Kansas v. Sesson. I'm just going to read from a proposed order, which I'm prepared to sign. Oral arguments are scheduled for this case at 9 a.m. on January 26, 2016. After 5 p.m. on January 25, 2016, Assistant Geary County Attorney Tony Cruz, on behalf of the state, filed a motion to waive oral argument and a motion to withdraw the state's petition for review. In his motion to waive oral argument, Mr. Cruz states that he has attempted to communicate with appellant Sarah Sesson's attorney, but has not received any response. The state's motion to waive oral argument and motion to withdraw its petition for review are hereby granted. The dismissal of the state's petition for review does not affect appellant's petition for review. Pursuant to our Rule 8.03, further appellant has not waived oral argument and will be permitted to present her argument to the court as scheduled. I'll be signing that in the next 2 seconds. After that, Mr. Hodgkinson, you may proceed.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Sarah Sesson, and I guess I don't need rebuttal. And Your Honor, I guess I would follow up on the procedure. As the court noted, I just got these orders this morning, and so I guess procedurally, would like to go forward. Although, according to Mr. Cruz's motion, I'm not sure. I guess I'm just not sure of what the next step is. As I understand the procedure right now, from the Court of Appeals order, the Court of Appeals ordered a new trial in this case. And Mr. Cruz has withdrawn, and you've granted his motion to withdraw his petition for review from that order. What I'm not clear on is he no longer interested in this district court case? That is to say, if it's that he agrees that there's a new trial and it's his intent to not retry Ms. Sesson in this case, then everything else is obviously sort of moot too. But I don't see that commitment from the motion that I received or from the order that you have. I don't know, I'm just talking to the court, if a sort of follow-up show cause of some sort saying, if he will commit to dismissing this district court case with prejudice, then I don't think we need to go any further. I mean, we're not here, I know this court isn't here in an advisory capacity. And
What if I suggest this, counsel? Number one, I assume you've not had any communication from Mr. Cruz.
I did not get
right.
I was not in the office after 5 o'clock last night.
What if we do this? If you're willing to sit down and we'll call the second case for argument, and during that time, if you could communicate or attempt to communicate with Mr. Cruz or ask the clerk of the appellate courts to do so in your presence, and we'll try to nail down what exactly he's prepared to do. If he says, yes, I agree with you, I'm not going to ask this case to be retried, then you've saved yourself some oral arguments. If he says no, then we'll see you back here in perhaps 20 to 25 minutes, ready to proceed. Is that acceptable to you?
That's extremely acceptable to me, Your Honor.
All right, very well, thank you.
Thank you.
Ms. Smith, will you be able to have somebody assist Mr. Hodgkinson in that endeavor?
Yes, sir.
All right, thank you. Case on this morning's docket, which I will recall. That is case number 110054. Before we proceed, let me simply ask for Justice Byers' sake, will there be oral arguments?
I don't think so, but I should announce to the court what we found out.
Sure.
Excuse me.
Yes.
Step out. Do you want
What
Judge
if
Malone
you-
to step back in?
If you wouldn't mind just staying here.
Oh.
No, I guess you're done. aren't you?
I'm finished.
Okay.
Thank you.
I feel like a real lawyer today, settlement negotiations at the last minute. This is what real lawyers do, isn't it? I don't live in this world very often.
All right, our senior judge, Mike Malone, is back with us now. Please proceed.
Your Honor, to follow up on our previous presentation, Ms. Peters and I, back in the lawyer lounge, were able to get a hold of Mr. Cruz, and informed him that you had granted his motions filed yesterday, and then asked him and told him sort of the situation and asked him directly, is it his intention to go forward with these cases in 12 CR 87, which is obviously the only case that I'm appointed to and that's before this court right now. And he indicated it is not his intention to go forward with that case on retrial from the Court of Appeals order. And Ms. Peters can confirm that. It was on speakerphone with me as we were doing that. So that being the case, if this case isn't to be retried, then I think the other issues are moot, so long as the court agrees that the proper disposition of this appeal is that in some way the 12 CR 87 be dismissed with prejudice. And Mr. Cruz agreed to that disposition. The clerk's office and I weren't clear exactly how that happens, whether it's an order of this court dismissing the case with prejudice as the disposition, or remanding it to the district court with orders to dismiss it with prejudice. But so long as either of those orders are entered, Your Honor, I don't need to go any farther. The other issues in this case would be moot. If you don't know that that's the right procedure, then I would need to go forward. Or, Your Honor, I can always come. I'm here on Thursday, too. I can come back on Thursday if you need, if you're not sure of how to proceed. That's my announcement.
It's your understanding, as confirmed by the clerk's representative, that there will be no prosecution in Geary County. Is that right?
In 12 CR 87, that's right.
All right.
And that he agreed to dismissal with prejudice.
Very good. Well, instead of our having to make a quick decision on that issue, why don't we just say that you're relieved of any responsibilities today to make oral argument, and that'll give us perhaps 36 hours to see how that would occur. If for some reason there's a glitch, then we'll see you back on Thursday. But if you do not hear from us on this case in the meantime, assume that it's been taken care of and you will not be arguing Thursday this case. Is that agreeable?
That's fine, Your Honor.
All right. Thank you, counsel.
Thank you.
Well, that concludes this morning's docket.